Thank you for joining us for our second ICOs and Securities law. This is part of our series hosted by Prysm Group on the economics of litigation and related topics. So for the schedule for today, we have a 90-minute slot. I'll be starting off with a half-an-hour presentation, which is what you see here. We'll then hear from Daniel Payne of the law firm Murphy and McGonigal, who will be presenting on the current state of litigation. And then the final half an hour will be question and answer. Throughout this, feel free to submit questions via the Q&A function. Our moderator will be moderating questions and submitting them at the end for us to answer. All right, so if there are no further issues, let's begin. So thank you for joining us. My name is Dr. Stephanie Hurder. I'm a founding economist with Prysm Group. We are an economics and governance advisory focused on projects that are in the DLT and blockchain space. So as many of you know, and most of the folks working in the DLT space know, there's a constant question of when does a token qualify as a security? And the SEC, of course, has been putting out guidance over time, so taking a lot of enforcement actions in this space. And a lot of the questions around whether a token is a security and other issues regarding tokens have an underlying economic basis. And we have found it through our advising that economic analysis helps to rigorously define what are the value of tokens, what is the expectation of profit for various token holders, including investors, and how decentralized is a platform. And as we'll talk about in this webinar, all of these are essential arguments in considering when a token is or is not a security, as well as other issues regarding expected return and expectations of profits. And as we'll talk about later, we view economic due diligence as an essential component of any investment decision or employment decision or anything related to a blockchain or distributed ledger-based platform. Blockchain projects are economic systems. In many cases, as we'll talk about, tokens are new currencies. And so economics expertise is just as important as legal expertise and technical expertise in creating a functioning, well-functioning system that delivers value. So as I mentioned, I'm a founding economist of Prysm Group. We are an economic advisory focused on blockchain. In addition to our work with both projects, we also engage in academic research, which has been presented widely, including at DARPA, and we regularly engage in economics education, especially focused on distributed ledger projects. All right, so for the first section of today's presentation, which I'm going to be leading, I'm going to go through 5 topics. The first is I'm going to talk about how we think about the economic value of tokens, focusing on a form of utility token called a means payment token. I'm going to talk about the relationship, what this model can tell us about specific criteria in the Howey test. I'm going to talk about whether fully decentralized platform governance and platform management is a possibility, and sort of how do we think about rigorously defining and evaluating that. I'll talk a little bit about best practices for due diligence when thinking about the economics of a blockchain-based platform, and then a brief summary. And as I mentioned, questions and discussion will take place after the second presentation. All right, so I'm going to start off by talking about some frameworks for thinking about the economic value of a token. Stepping back just a little bit, when we think about a blockchain-based platform, basically any project, we think of this as an economic system, and the token is one of several layers that goes into the economic system, right? So if you're launching any kind of platform, you obviously have some kind of value proposition. You're offering a product or a service to somebody who's going to be willing to pay for it. You've raised some initial capital. And then there's a whole series of different economic design decisions that need to be made if you're running a marketplace, even if it's just a marketplace for transaction processing. If you're going to have contracts between buyers and sellers, if you're going to have reputation systems, sort of all of these things are economic structures that need design. Those are a topic for a different time. But when we think about tokens and tokenization and token design, the token serves an economic purpose, and it should be there for a reason, and it interacts with the other structures on the platform. So the token can't be divorced from the rest of the economics of the platform that it's going to be launched on. It interacts with all the different components. As we'll talk about later, governance is something that comes up more and more, has to do with decentralized decision making, and can have an impact on the token. So the point of showing this is just to highlight that when we think of a token, we think of a token as part of a larger economic ecosystem, and that frames all of the frameworks that I'm going to be discussing from now. So when we think about the economics of a token of a token versus what's the price, right? So the price is sometimes called the exchange rate. How much money can I get for this token at a given time? The fundamental value, and we typically just call it the fundamental value, but here we're really thinking about the economics, is a function of what are the property rights granted by the token, right? So when you get a token, it's giving you the rights to some goods and services. It could be a portion of a building, partial ownership of a building, or it could be the right to purchase decentralized storage space on somebody else's computer. There's some element of rights that are given to you. And the question is, what is the value of those rights? And when a platform is launching, the specification of what are these rights is one of the most important decisions that the founding team has to make. And they need to think really carefully about it, because as you'll see, it fundamentally impacts the value trajectory of the token and the factors that can impact the token's value. We tend to think of the difference between the price and the value. Sometimes we think of it as speculation. Sometimes we think of it as future expectations. But they're pieces that we think of as divorced from sort of the concrete benefits that the token provides. So when we advise, we focus on value creation and value growth. And if you want to run a pump and dump, you can, go talk to somebody else. So as all of us know, there are a number of different kinds of tokens. Token taxonomies change all the time. Most of the tokens that have been addressed in current actions and enforcement actions around ICOs are utility tokens. The most common of those are what we refer to as a means of payment token, which is just sort of a standard utility token. You've purchased it, and the main use of the token is that you use it to buy digital goods and services on whatever the platform is that has been launched. In the case of something like Bitcoin, you can use the Bitcoin to pay for transaction fees on the Bitcoin blockchain. You also may be able to use it for other things off the platform, but sort of the fundamental initial use case is using it for this particular set of services. You now see more tokens that involve, staking and staking contributions, governance. On the other hand, you can have security tokens, which give you the right to cash flows or profits or part of a, partial ownership of a concrete object. But there are different types of tokens can be categorized by what kinds of fundamental value via property rights they're giving their particular holder. And so first, I'm going to talk throughout this webinar, I'm going to focus mostly on our economic framework for thinking about the value of a means of payment token, because this is the meaty legal actions, because they were launched a while ago. And so when we think about, but each type of token is going to have its own distinct value proposition and equation for estimating value, and I'll talk about that a little bit more later. So when we think about the rule of thumb for the value of a means of payment token, so token you use to buy digital goods and services, the rule of thumb we use, and this is based on more complex academic research, is that the token is a function of the economic activity conducted in tokens. And you can think of this as something similar to GDP that we use in regular economies. as well as the circulating supply and the token velocity. So the numerator is basically how much economic activity is this token being used to buy or sell, and then it's moderated or divided by the number of tokens basically in circulation times something called the velocity, which is how often each token is used. And I won't get into the details of this, but just this framework allows us to think about the different dynamics of token value. So for example, if you think about, you know, the rule of thumb indicates that the value of a means of payment token is going to go up when economic activity increases. You know, what kinds of things constitute economic activity? It's things like people want to pay transaction fees in tokens. They want to buy goods and services on dApps in tokens. They want to buy goods and services off dApps in tokens. These are all things that, according to this framework, are going to increase the value of the token. Circulating token supply, which is the number of tokens that are actively available to use, is impacted by a number of things. You know, how many tokens are available at launch, how many are being newly minted, how many are being released from vesting, how many are being burned or locked up, for example, in a staking contract. And so you can already start to see, you know, what are some of the different economic levers, and we'll decompose this a little bit in the next section, that drive changes in the economic value of a token of this type. And I'm going to go back to the means of payment token in the next section, but just as a contrast, suppose that we were thinking about the value of a security token, right? Suppose that we have a security token that is tokenizing ownership of a commercial property. We're going to have 1,000 tokens, and each token gives you an ownership share of 1/1000th of the commercial property. In order to think about what is the value of this token, the design of the token and the rights that the token gives you, actually, the design is quite subtle, and subtle decisions that a lot of teams don't think about actually impact the value. So for example, if you were trying to determine the monetary value of this token, you would want to of the property. Do you have rights to use the property, right? Can you go in and use it, or do you only just look at it from the outside? Do you have rights to income flows that are generated by the property? Do you have requirements to contribute to the upkeep of the property? And do you have the rights to decision-making processes, right? And you see, for those of you familiar with the pricing of shares, you know, typically minority shareholders have their shares priced slightly differently than if you have unilateral decision-making power. But all of these different factors go into an economic model of how these shares would be valued. And the important thing here is that this can be modeled, right? You can take these and put them together. You just have to think very carefully about the economic fundamentals of the rights that the token is giving you. So how does this relate to the Howey test? Obviously, we're familiar, all of us on the phone are familiar with the Howey test. It defines a security as a contract, transaction, or scheme whereby a person invests his money in a common enterprise and is led to expect profits solely from the efforts of the promoter or third party. We're going to focus on the bolded section, which is the expectation of profits and the efforts of the promoter or third party. I know that, you know, most blockchain projects have been ruled to be common enterprises. And we're going to ignore things like airdrops. So you've purchased a token in a common endeavor, and then the question is around, do you expect profits and where are these profits coming from? And I've actually been very impressed with some of the guidance that the SEC has put out in terms of the economics. And I think what the economics can add here is the rigor, is saying, you know, these are the different factors, these are the different actions that different parties can take. This is how they're going to impact the token value, and therefore, you know, whether the token delivers profit, if, you know, token holders should be expecting profit, and so forth. And one thing you will notice as we go through this is that once you think about this in economic terms, it's very difficult to sort of construct a token that would not be classified as a security, and we'll go through that. But you know, there's been some preliminary rulings that, for example, Bitcoin may not qualify as a security. That is sort of the one example, and most of the other projects are going to fall into categories where there is a significant relationship between active management and the value of the token. So the first thing I want to talk about, and we're going to focus on these means of payment tokens because they're so common, is that there's a fundamental sort of incompatibility between having a means of payment token and offering it as an investment. Payment token, it's more or less a currency. You're offering it to facilitate, if you're planning to use it for its intended purposes, you're offering this token as a way to buy and sell digital goods and services. And when you have a currency like this, you want it, consumers want it to have a relatively stable value, right? Volatile currencies are not attractive to anyone. If you have a highly volatile currency, it's going to prevent users from buying and selling the goods and services that your platform offers, whether it's decentralized storage or ownership of digital music rights or whatever. Having a highly volatile value of your means of payment token is unattractive. So you want it to be sort of relatively flat. So this in and of itself is not an attractive proposition for investors, right? Investors want significant returns. So for a well-managed means of payment token, the primary return is really going to be between the pre-sale and the platform launch. And this is where the founding team is going to be the most active. And so there's this fundamental tension where maybe in the long term a platform is more or less decentralized, everything has been set up, it's sort of running, but in that case you don't really want a token that's increasing at 20% a year in terms of its value. So there is this fundamental tension. And this is something that a lot of teams that are planning ICOs have a really difficult time with, because this fundraising impetus is fundamentally at odds with the type of token that they are trying to launch. So when we're thinking about monetary policy for a means of payment token, whether you want to have a significant pop at the beginning, right? If you want a significant price increase between the pre-sale price and the launch price, or whether you're trying to maintain a relatively stable value in the long term, there needs to be an active management between the circulating supply of the token, which is what we saw in the value equation, and the growth rate in economic activity over time, right? If you remember, the value of the token in that rule of thumb was the economic activity taking place on top and the circulating supply on the bottom, and you want this ratio to fall within whatever bounds you have, right? If you're trying to get 20% per year price increase, you want one to grow much faster than the other. If you are looking at long-term stability, you want them to retain relatively in proportion. And this requires a great deal of management, right? So in order to be able to do this, you need to, at the very least, have a good idea of what economic activity is going to look like over time. As we'll talk about, this frequently needs active management. And then you need to be able to regulate platforms. The success, having a token that is at least stable, if not increasing in value, requires active management and investment in particular activities. And these all come down to getting people to use the token to buy goods and services, right? So how do you attract successful dApps that use the token as a means of payment? How do you facilitate successful transactions, right? So if you think about, even if you have a marketplace, there are actions you can take on the marketplace designed to make it easier for people to find each other, to transact, to come to mutually agreeable prices and other terms. Making that easier gets people to use the token more. And there are a variety of other activities. And so when we think about how to achieve this, it is very common that platform teams need to actively manage and provide incentives for third parties to engage in the activities that are going to help with this. So sometimes a variety of different things that you'll see that we'll end up recommending are things like, if you're offering a protocol and you want dApps to come and build on your protocol, frequently you need to seed the dApp supply. So this is the Apple Store model, right? When the iPhone launched, Apple actually produced all of its original apps and then opened up the App Store for third-party developers. But seeding the protocol shows how the platform can create value. And then you have third parties come in. And this is typically needs to be done by either the founding team of the protocol or an affiliate. Frequently, platforms want to have ongoing screening criteria for dApps, right? It is in their best interest that the systems that are being offered are high quality, and therefore they might have requirements about, the dApp must use the token as an exclusive means of payment. There may be design standards that are implemented, and this requires ongoing vetting. You may offer incentives, right? If you build on our protocol, we will offer you, we'll have a contest, we'll give you a grant to incentivize you to do this. This is all active management, and these are programs that frequently need to be revisited over time. But if you want economic activity to go up in expectation or economic value, you need to be thinking about these types of things. The other side of the value equation is obviously managing the number of tokens in the circulating supply. And they need to grow at a certain rate depending on, what is the value trajectory you want for the token, and how much economic activity do you have. And if the token supply is growing too quickly, your token value is going to crash. If the token supply grows too slowly, consumers are going to refuse to spend the token as a currency because they're getting a 20% return on the token that they're holding. And so what teams have found is that achieving these goals with a completely decentralized algorithmic model is extremely difficult, right? So on the one hand, you may need active ecosystem management. On the other hand, there's substantial uncertainty in exactly who is going to use the platform for what when, and therefore predicting in advance exactly how many tokens you need at every point is extremely difficult. So some platforms will retain a substantial treasury of tokens to use at their discretion. They may release them into the circulating supply. They may give them out as incentives for developers. And so and these actions are frequently necessary in order to, build and maintain the token's fundamental value. In addition, frequently early investors and employees will be some of the key recipients of early token allocations, and they will get quite significant allocations at a quite significant discount as their compensation. And then these tokens are released over time. So this is another element of sort of central control that frequently comes up, is that you'll have employees holding and then selling as they vest significant token holdings that then impact the token's value because they're changing the supply of tokens in circulation. And so the thing to take away from this is that many protocols offer, for example, they increase their newly minted token supply through block rewards. The block rewards are determined in advance. But doing this is unlikely to result in an attractive investment product, right? Or if the investment product is attractive, it's going to be because of what we would call sort of non-value driven price dynamics. It could be speculation or future expectations or whatever, but it's not going to be driven by sort of the fundamental economic value of the token. And so just at a high level, you can see that when you think about what are the value drivers for a means of payment token, and specifically having this value framework allows a rigorous connection between the different management levers that get mentioned in guidance and the token value and the expected sort of price trajectory. So one thing I do want to touch on is that in a couple of the enforcement actions that have been taken, there has been a question of governance. We have decentralized decision making, and so this management team doesn't actually have a lot of power. This is really a decentralized platform and should be considered to be a security. And this is a really interesting point, and achieving this kind of full decentralization is a goal of a lot of different platforms. And at a high level, what we've seen is that there hasn't really, that level of decentralization hasn't really been achieved yet. Or if it has, it's been achieved by at most one or two protocols. So when we think about sort of why am I calling this governance? When we think about governance, governance is basically the process of making changes and decisions that aren't already specified in the code base, right? So you have sort of the code base and the operations, which is the hard-coded stuff that goes into the platform. And then you have governance, which are things like we're going to change the protocol, there's a crisis that's come up, all of these different, we need an incentive program that isn't in place. It's sort of all of these different activities that haven't already been hard-coded, and a decision needs to be made by a collective group of people. So when do you need governance? You want to upgrade the system, you want to make a change, or the system has gone into crisis, and you want to make this decision in a decentralized way. And the thing that we see with governance is that designing a truly robust, decentralized, powerful governance system is extremely complicated. And this is what we call the wheel of the elements of economic design of governance. And it is our framework for thinking about what does a truly comprehensive governance system look like, right? If you wanted to say that the governance of a particular system is truly decentralized, these are the different pieces that we would go through and check to see if these are in place. And if you don't have these types of infrastructure, such as, not only a well-defined proposal process, but processes by which to distribute information, processes by which voters or token holders can speak to each other, it's really difficult to say that the governance, as opposed to the founding team or whoever is in charge, is the one that's controlling the system. A couple different examples of this. For those of you who are familiar with the DAO hack from now a couple of years ago, if you remember correctly, there was this question of, are we able to basically undo the hack, or is it truly an immutable blockchain? And this ended up going, the decision-making of what to do ended up being brought up several levels to sort of a core small set of decision makers who actually weren't formally in charge. It was sort of their folks. And so at this time of crisis, even though Ethereum liked to think of itself as relatively decentralized, and especially the DAO did, at the time, when key decision making was required, the decision making ended up with a much more centralized group. And frequently, another example of sort of another situation that happened more recently that showcases the current incompleteness of most governance systems is the MakerDAO crash that happened on Black Thursday. So for those of you who aren't familiar, in March, when the stock market tanked, the price of Ethereum crashed, and MakerDAO, which is a stablecoin that uses Ethereum as one of its collateral coins, had to sell off a whole bunch of currency in order to keep the reserve balanced. And the system did not work as intended. There were a number of different glitches. And what they found at this time was that their decentralized crisis governance wasn't actually sufficient to address this. It had not been fully specified enough that it was able to handle this situation. And so there are tests like this that demonstrate, is this decentralized decision-making process where token holders ostensibly have decision-making rights actually robust enough to really manage the platform? Apologies. And so when we think about economic due diligence, some of the things, when we've audited dozens of projects, and we typically think about sort of what is this platform promising to do, and have they built the economic infrastructures required in order to deliver on that value? And that's something that we frequently do for potential token holders, for potential large-scale investors, for the platforms themselves. But if we think about the best practices for due diligence, because of the relationship if you have a token that is going to deliver expected profits and is going to do so because of the fundamental value that the token requires, you want to make sure that the platform's design is going to deliver that value, right? So you're going to ask questions like, what is the token going to be used for? Are there concrete use cases that are going to be specified? Are the fundamental market structures required to deliver on that value there, right? Do you have pricing mechanisms and market mechanisms? If you have auctions, are they in the works? Are they going to be rolled out? What does the governance look like? What are the mining, staking, reward mechanisms? And who is going to deliver on these, right? And as I mentioned earlier, value that an organization is going to deliver, it almost always requires coordinated action and planning and effort by a core group of individuals. And setting up a fully decentralized process that can deliver all of the infrastructure required to grow economic activity is extremely challenging. And just as a benchmark, and we have a couple different quotes here, many of you are familiar with Blockstack. There have been questions about sort of what does due diligence cost. Blockstack took a slightly different approach. They've been approved for Reg A+, and their estimates are that they spend about $3 million in legal fees to make everything amenable. And so just in summary, what I hope that you can see from this is that even on top of the guidance that the SEC has provided, economic analysis can add a lot of rigor to understanding what is driving a token value and the expectations and realization of profits, and the different activities taken by different stakeholders on the platform, right? So each type of token is going to have a different value, sort of set of value drivers. Even a means of payment token that has staking uses a completely different model than just sort of a pure currency. And once you understand those value drivers, you can understand, again, the relationship between various activities and the value of the token. So for a means of payment token, typically if you're looking at a substantial increase in price or value, there's going to almost always be active ongoing management of some components of the platform. And truly decentralizing this type of activity is extremely difficult. You can see this in whenever there's sort of a hack or a bug, you can see what platforms do. Are platforms able to handle this in a fully decentralized way? And we do recommend that anyone who's looking to invest in a token really carefully understand what are the economic mechanisms that are going to be required to deliver the value that's necessary to support the token, and are they being fully specified? And so we see, the ongoing guidance provided by the SEC and others as really promising. We really like the economic considerations that they're including. And we think that formal economic analysis can add to these arguments by formally specifying the relationship between various activities and the expectations for the token. This up, I will now hand things over to Daniel.
Hello, everyone. All right. I assume I'm coming in loud and clear. And Stephanie, thank you so much. That was fantastic. So much good stuff in there. I could spend all of my time just responding to all of your points. I wanted to talk about Blockstack and decentralized governance and the impact it has on litigation. I'll try to stick to my prepared materials mostly, but that was great stuff. Okay, let's see if we can swing around to my deck here, and we will, let's see. All right. So I hope that's coming in nice and clear for everybody. thanks for attending. Thank you to Prysm, Stephanie, for having me on here. Today we're going to be talking about trends in crypto litigation and the state of litigation in the blockchain space. Again, my name is Daniel Payne. I'm a partner at Murphy and McGonigal. Just a quick introduction of myself and my law firm. Murphy and McGonigal is a financial services boutique law firm focusing on litigation and regulation. We've grown from 14 attorneys back when we opened our doors in 2010 to over 50 attorneys at the present time. We're coming up celebrating our 10th anniversary coming up on June 1st. So we're very excited about that. Murphy & McGonigal has a robust fintech and blockchain practice with former SEC, CFTC, FINRA, and New York Department of Financial Services attorneys, all with a lot of crypto expertise that we all bring to the table. We represent well-known, large, established cryptocurrency exchanges, crypto funds, alternative trading systems, as well as broker-dealers and token issuers. I personally have been at Murphy & McGonigal since day one. It's a great place. I was a member of the original 14, and my practice focuses on securities litigation and regulation. And on the crypto side, I focus on assisting companies with complying with the murky regulations governing blockchain companies, litigation involving cryptocurrencies and blockchain companies. So one of the big things that's been keeping me busy the last couple years is this blockchain litigation database that I helped create at our firm. And the blockchain litigation database is a tool we use to track all of the blockchain litigation in the US. So this is not worldwide, this is just domestic litigation, but it includes civil as well as criminal and state and federal enforcement actions. So there's a lot of different kinds of cases in the database, and by tracking everything together, we can get our arms around some of the trends and do some analytics in terms of comparing cases over time and comparing cases as they're filed, comparing the claims, the parties, and get some real insights into what's going on. And that's why we created it, and it's a really, really useful tool. There's always a fine line when we're deciding which cases go in the database. So just so you can kind of get a feel for what kind of data we're working with, just because a case, the complaint in a case mentions Bitcoin or Ether or cryptocurrencies generally, is not enough to really put it in here. There's a lot of actions we've seen where it just so happens that one of the parties had some Bitcoin and that is mentioned in the course of the complaint. We are focused on core crypto cases where this case has the potential to really decide some legal issues that are going to impact the community. So we want there to be core crypto issues in all of the cases that we're tracking. But that said, we're casting a very broad net to try to get as many of those cases as we can. So throughout my presentation, you'll see some charts and trends and everything. They all come from the blockchain litigation database. So this first one, this comes right out of the database. And this is our chart of cases filed over time. And the first thing I notice when I look at this kind of exponential growth in cases and then a crash between 2018 and 2019 is it's not dissimilar from a smoothed out graph of the price of Bitcoin over time. The price of Bitcoin or something that isn't quite reflected here in the same way, but the general picture here is very similar with one big exception. The spike in the price of Bitcoin when it went up to almost $20,000 was at the end of 2017, and the spike of cases we see here is 2018. But this is no accident that this chart looks very similar to that chart with a couple of differences in timing. The adoption of Bitcoin, the additional speculation and investment that drove the price up, is precisely what led to this additional litigation. When the crypto winter, so to speak, happened in 2018, that was when Bitcoin crashed down from 20,000 down to the $3,000–4,000 range over an extended period of time. A lot of people lost a lot of money, and federal and state regulators came in to clean up what they saw as the ICO mess of 2016 and 2017. And so that led to a huge spike in cases in 2018. And so I've got that highlighted here, this spike. There was a task force of state securities regulators who worked together to do an investigation and then bring these cease and desist orders and enforcement actions against a lot of the ICO issuers. And that state-run effort, really explains a lot of this bump in 2018 that really bumps it off of the previous trajectory you can see here on the second chart. In 2019, a lot of the state activity dried up, so the number of cases still increased fairly dramatically from 2017 to 2019, but it looks like it was coming down off of this spike in 2018, but I think it was just returning to the previous trajectory that it was on if you subtract out that bump from state securities regulators. But again, later in the presentation, we'll see is the price of Bitcoin at all an indicator of continued crypto litigation? And we'll get into that. So I spent some time on the last slide talking about how the state securities regulators were bringing all these actions, but the federal regulatory enforcement landscape is pretty interesting as well. I can see on my first chart here, it looks like one of my slides, one of my little labels here got hidden. That should be the FTC behind here. Is that there are multiple federal regulators bringing enforcement actions. And of course, that highlights the fact that it is a murky regulatory landscape where multiple federal regulators are asserting jurisdiction to go out there and bring enforcement actions in this space. So that's a key point here, is that figuring out whether your token is a security or not is not going to get you all the way there if the CFTC decides that your token is a commodity and you've somehow violated the Commodity Exchange Act, the CEA, or if FINRA decides that you're acting as an unregistered broker-dealer because of the way you're trading cryptocurrencies. Just because you're safe with the SEC isn't quite going to get you where you need to go. Now, the overall number of federal enforcement actions actually declined from 2018 to 2019. So this, I think, got cut off of my slide, but in 2018, which is on the left here, there were about 27 total actions. And then in 2019 here on the right, we only had about 25. So that's pretty even, right? I mean, the CFTC, FINRA, and the FTC are not filing enough actions to really form any kind of pattern or trend. So if they file a couple more in this year and a couple fewer in that year, it might impact at the margins the overall level that we're seeing. But the SEC is really the driver of actions here. And between 2018 and 2019, the SEC actually increased the number of actions that it brought. And that's really interesting, right? 2018, as we saw, was the big effort from regulators to clean up all the ICOs filed in 2016 and 2017. And then the state regulators kind of were all done, but the SEC was just getting started. And in 2019 and so far in 2020, they've kept up their pace. And that's notwithstanding the other guidance that they've been putting out there. They've issued a no action letter that a token for this it's called Turnkey Jet that offers miles on private planes, that they could issue a utility token in very specific narrow circumstances that would not constitute a security. The SEC has come out with its framework for digital assets. It came out at the end of 2018 with its path to compliance in connection with a couple of enforcement actions. Notwithstanding all that guidance, they're still bringing a lot of enforcement actions. Now, what is the overall SEC strategy here? What's going on is we don't yet have strong court precedents guiding the courts and the community around the application of our current legal system, our current laws, to cryptocurrencies. So there's been a lot of litigation, but we haven't gotten to a point where that litigation has turned into key precedents that courts and the community can rely on yet. The SEC is trying to change that. They are bringing high-profile actions that they're fighting tooth and nail, bringing them in court. They want some precedents where that will establish that their view is correct, and the application of the securities laws to cryptocurrencies is what they say it is. So of course they don't want to lose, but even more than that, they need some precedents, because all they have right now are a bunch of their settlements, which are instructional, but they don't represent precedent that any court has to follow. And the only other thing they have is Howey. And that's what all the courts are applying. That's what they have to apply. That's what's there. And we went through the elements. I'm sorry, Stephanie went through the elements in the earlier presentation, so I'm not going to rehash them. But those elements of a common enterprise, an investment of money into a common enterprise with an expectation of profits dependent on the efforts of others, that is the framework that all the courts are using. Now, is Howey anachronistic? Is it perhaps a poor framework for a court to analyze whether a cryptocurrency is an investment contract and therefore a security? It was designed to be malleable and apply to any different number of situations, and it's done very well over the past century. But cryptocurrencies are something very new, that are perhaps beyond what the authors of Howey could have even imagined. And sometimes the analysis just doesn't really make sense. And so Congress actually recognizes this. And a couple of years ago, they introduced the Token Taxonomy Act to redefine certain digital assets as non-securities. That law has not been, that bill has not been passed. It's not a law, but Congress recognizes the need to update our laws. But right now, the SEC is Howey all the way, and they want to enshrine their interpretation of it in some key precedents. So that brings us to these three high-profile actions that were brought last year. So Kik is a popular messaging service that's run on a blockchain, and they wanted to issue their token called KIN. When the SEC started investigating them and threatened to bring a suit, Kik made an interesting decision to go public with this and seek support from the community. So they issued their Wells response. They paid a lot of money to a very well-known, reputable law firm to defend themselves against the threat of litigation. The SEC didn't bite. They filed suit, and this has been a really intense battle for going on a year almost. and we're now at summary judgment stage. So we could get a very interesting ruling with some real impact here, because summary judgment is far along enough where discovery has been taken, and the court could make some really important rulings in kick. So we'll see which side prevails. Block 1, this was a settlement. This was not a litigation. Block 1 decided to settle allegations that its ICO was unregistered, relating to the money that it raised from American investors. So Block 1 raised $4 billion worldwide, but it appears that the fine, which was $24 million, was only related, or at least mostly related, to the money that was raised from American investors. The allegation in the settlement was that the American investors were the ones covered. The SEC didn't try to apply the settlement to the ICO worldwide. But the SEC can point to that. Again, it's not a precedent, this settlement with the SEC, but they can point to that as another brick in their wall of enforcement settlements, saying this company agreed that it had an unregistered security offering. Same with this one, and Block 1. And so they're trying to build a wall through their settlements when they don't have to go through court. Now, Telegram has gotten the most publicity most recently because of a really important ruling. So Telegram took the approach of dividing its offering in two. And they viewed it as two stages, two different transactions. The first transaction was an exempt securities offering. So they agreed that when they first sold their grams to the public, to the initial purchasers, that was a security with the rules around having an offering that is exempt from the application of securities laws. They did it under Rule 506. Then the second half of the offering was going to be the delivery of the grams, which they argue was not a securities offering and didn't need to be exempt, did not need to be registered. It was fine as is. And they viewed them separately. And in the middle, between stage 1 and stage 2, the SEC came in and said, you're doing an unregistered securities offering, stop now. That was last fall. The SEC and Telegram actually agreed to the TRO, the temporary restraining order, for Telegram to not do the second stage, not deliver the grams yet, while their legal dispute played out. And so the first round 1 of the lawsuit was just won by the SEC at the end of March. And so that round was the motion for preliminary injunction. So that extends the TRO through the end of trial. The TRO is just temporary, just to give the parties a little breathing room. Preliminary injunction lasts until the case is over. So it's not the permanent ruling, it's preliminary, but it lasts a lot longer than the TRO, and there was a lot of heavy briefing and argument to the court on the motion for the preliminary injunction. And the court ruled in the SEC's favor. And the court said, these two stages, this is all one offering. This is one transaction. There's no such thing as stage 1 and stage 2. We put them all together. It's a securities offering, and the court issued the injunction to keep Telegram from issuing the grams. So the analysis of Howey and Telegram is a very important precedent so far, perhaps the most important precedent that's come out so far from a court. The next step was Telegram came back and said, okay, we lost, there's this preliminary injunction, but it should only apply to our delivery of grams to American issuers, not foreign investors. They're not covered by the US securities laws, so we should be able to deliver our grams to them. And that implicates a legal framework called Morrison. This is a Supreme Court decision from 2010 that limits the application of the US securities laws to securities transactions that take place in the US, more or less. And so Telegram said, based on Morrison, you need to limit the injunction. The court replied by denying Telegram's request about the scope of the preliminary injunction early enough so you're procedurally barred. But substantively, the court said, this is all one transaction and all of the initial purchasers are expecting a profit based on their expected future sale of grams in a secondary market. So even if that initial purchaser is foreign, the secondary market will include American investors. And so that is enough to get past Morrison, and the injunction is worldwide. So that was another really important ruling. These are the kinds of rulings the SEC is going for here. Okay, we're getting close to the top of the hour. So I'm gonna run through the rest of these slides a little bit more quickly. This chart here is our mix of case types. So you can see civil enforcement actions are a solid quarter or something. Private civil actions, along with derivative actions, are the biggest buckets. Most of the derivative actions, that's just another flavor of civil actions. That's the bulk here, and criminal actions are 20% or something. I'm trying to figure out the percentage on the fly here, but earlier on, a few years ago, criminal actions were the overwhelming majority. So the mix has really changed with the more widespread adoption of cryptocurrencies. There's more civil litigation, whereas before there wasn't so much civil litigation. There wasn't a lot of economic activity using cryptocurrencies, and the main use was criminal activity. And that's why you would have seen a lot of our earlier cases in the database are criminal. The criminal cases that we see now are different than what we saw earlier on. The earlier cases were criminals trying to complete a criminal act, and they just so happened to use cryptocurrencies, but if there was no Bitcoin, they would have been using dollars. So Silk Road is a great example of this. Buying and selling illicit items, illegal items, cross-border transactions, money laundering. The people involved know that this is a transaction that cryptocurrency helps facilitate. Hey, Silk Road is great, but these are transactions that presumably would have been taking place anyway. Now we have crypto-based criminal schemes. So I picked this example because it's a circus. It's very interesting. It's got interesting facts. The OneCoin platform raised billions of dollars, but it was a fraud, and it's been frittered away, and the investments from investors have all been lost. The so-called crypto queen who ran the whole thing, she's on the lam. Nobody's seen her in a year or so, and so she's not been brought to justice. But a New York attorney named Mark Scott was in the U.S. He did not escape. He was arrested, went to trial last fall, and was found guilty. It was very interesting. He said, look, I don't know a lot about cryptos. They just hired me to handle some bank transfers. There was somebody else at my firm who was the crypto expert, but it wasn't me. But the jury disagreed. He was paid a lot of money for his services, which suggested maybe a premium for criminal acts. And some of the bank transfers were very suspicious. So interestingly, he's been whipsawed recently. He was out on bond pending his sentencing hearing. He got remanded back on March 12th because his bond was no good and he violated the terms of his release. But then COVID-19 hit the U.S. and a couple weeks later he was ordered released. So he's been in and out and in and out. We'll see what his ultimate sentence is, but so goes it. most common venues, this is the kind of interesting trend or analytic that we can see using our database. So New York and California, perhaps unsurprisingly, show up in the top 5 venues where these cases are being brought. But then there's Florida, the Southern District of Florida. What is it doing there? Well, we were able to dig in and see that Florida makes the top 5 on the backs of 2 plaintiffs firms who have done a brilliant job of rounding up some plaintiffs to bring some crypto cases on their home turf. That's where the plaintiffs firms are. So sometimes if you want to figure out why there's a lot of cases in one spot, you can look at the law firms and that can explain it. So that's always very interesting. So a quick 2020 update. 2020 is not taking us to a new high, excluding the spike in 2018. It's not taking us to a new high on that trajectory we were on, but it is keeping pace with 2019. So while the price of Bitcoin has been in a range of 5,000 to 10,000 over the past year, since I guess last summer, which is fairly consistent as the price of Bitcoin goes, we're having fairly consistent crypto litigation. I think over time, the pace will pick up. I don't think it's going to be on that same trajectory, but I think cryptocurrencies are and digital assets are going to continue to be slowly integrated into the economy, and the pace of litigation will necessarily pick up over time as that occurs. There was a new wave of private civil actions. These were class actions filed against ICO issuers and exchanges earlier this month. These raise some really important questions about statute of limitations, because these are ICOs from a few years ago, and some of the SEC laws have 1 or 2 year statutes of limitations, so they could be barred if they can't prove to the court that their claims did not arise within the last year or 2, even though the ICOs were farther back than that. And the cases involve some international defendants, so it'll raise key questions around Morrison, like I talked about earlier, the extraterritorial application of the securities laws, and also around personal jurisdiction, so trying to reach these defendants who are in Asia and Europe. So that's it for me. I'll turn it back to Stephanie as we hit the Q&A.
All right, that was great. Thanks very much. So we now have some time set aside for Q&A. Reed, our host, will be moderating some of those questions. So if you have any questions for either Daniel or myself, feel free to submit them via the Q&A app at the bottom of the Zoom screen. So with that, Reed. So the first question that we have is, why do you think there are so few truly decentralized blockchain platforms? And I think this is something that we have seen a lot of different projects, both that we work with and don't struggle with. And I think there's a couple of different challenges. So first, especially in the early stages of a platform, with any kind of project, adaptability is really important, being able to make quick decisions. And setting up a decentralized decision-making process that allows you to respond really quickly is really, really difficult. And it typically requires a lot of hard conversations right up at the front that teams may not necessarily want to do. So sometimes I'll refer to it as sort of the premarital counseling. Like, you need to have in order to have robust governance, you need to have really difficult discussions really early in the design of the platform. And people typically don't want to talk about, hacks and crashes and stuff like this. So maybe one day we'll get there, but I think we see a lot of cases of sort of governance design that was postponed because it involved hard topics. And then it turns out that when there's a crisis, a core team of somebody has to step in, and the system isn't really as decentralized as you would think.
I've got the next question, and it looks like you guys are asking some fantastic questions. Thank you for that. That is too rare on the webinar. So the first one is to share some comments regarding why there hasn't been more private litigation against ICOs. The thinking was that there would be an explosion after the early SEC positions and then crypto winter price drops, but it's been relatively quiet. So I think there's a couple of issues here. Bringing private litigation is not free. You've got to find an attorney willing to do it. And there are only a lot of plaintiffs' attorneys work on a contingency so that if you win and you get some money, they get a piece of that money to pay for their work. That's a totally fine model, but that's a hurdle for these ICO investors. So they absolutely suffered losses. Presumably, there was some violation of the securities laws in most of those ICOs. I think we can safely say that. But if the issuers, the token issuers, have spent all the money or they are gone, then it's going to be extreme understand that and may not be willing to put in a bunch of time to get a judgment on which they can't collect. So that's a tough hurdle. The separate answer, I would say, is some investors may be counting on the SEC to eventually get down to their whatever ICO they invested in and force that issuer to offer rescission, in which they kind of unwind the transaction and buy back the tokens, which could work out if the SEC gets there and if there's money to make a rescission happen. But I think a lot of the money is kind of gone, so to speak. So the actions that are going to happen are against ICOs that were successful, and there's an ongoing concern, and there's money still there, and it's being used. And if that's the case, maybe you don't want to bring an action because you've got a token that may be valuable even if it was issued improperly. So those are a few thoughts.
All right, great. So the next question that we have is, what current design trends are susceptible to lawsuits? So first I want to preface this. I am not a lawyer or broker-dealer. I am one of the only non-lawyers on this call. So this is not official legal advice. Daniel, I'm sure, has a lot of thoughts about this. Purely from the economics point of view, a couple of things that we do see, I don't know if they're lawsuits, but sort of what I would classify as unwillingness to fully embrace the underlying economics of a token. Two things that come to mind are, one, platforms still want to raise money that is orders of magnitude more money than the business that will be conducted on their platform in the reasonable future, right? So I think we always hear the EOS token offering as an example, but just people want they want to raise billions of dollars. And they're never going to have billions of dollars on their platform. And so you have to sort of go through that. Another design decision that we're seeing is more and more tokens are being used as a combination means of payment staking token, right? So you can use the token to buy and sell goods and services, and you can also stake it, and in exchange you get a stream of tokens. Sometimes they're newly minted from the platform. And that model is actually a pretty good way in the short term to bump your token value, right? Because at the very least, you can stake your token and get some tokens, but it's kind of, if you don't have the fundamental use of the token, if you don't have the economic activity, if people don't want to use the token for actual purchases, it's kind of like a Ponzi scheme, right? You're getting paid additional tokens for your token, but the fundamental token doesn't necessarily have a lot of value. So those are just a couple. I'm sure Daniel has a lot of thoughts on this, but those are some design decisions that I see that are, as I said, are sort of not quite there on the economic realities.
Thanks, Stephanie. Yeah, I'm going to be careful what I say about those. And actually, I've got another great question, so I'm gonna keep the ball rolling. Are you keeping track of judges across the most common districts in your database, and do you see any patterns in their understanding of crypto? This is a great question. This is a pattern that we are looking for, although we haven't found it yet. So we are tracking judges, and we hope that when judges start getting enough of these than other judges. We haven't seen that yet. For even the judges that have had a couple of these, the cases are either exactly the same, and that's why they got them. So they haven't had a chance to hear from different attorneys and see different cases and bring up their understanding. It's just the same arguments being made to them. And it's really the same case, maybe in two different formats or postures. Or the judges are just getting one-offs. And I'll give you a very quick example of why we hope judges will start improving their understanding of crypto and blockchain as two things happen. One, they need attorneys in front of them who are experts in crypto and aren't winging this. And number two is as they can rely on precedents from other judges who have a good understanding of this, neither of which is present right now. But what we have right now are judges like a judge in the Northern District of California who issued a ruling on the application of U.S. securities laws to Tezos, which is a Swiss ICO issuer. And part of so this is the Morrison framework I was talking about earlier. The judge was doing a Morrison analysis, and part of that analysis, this wasn't the whole thing, I'm not throwing the judge in the river or anything, but part of the analysis was the blockchain confirmation of the securities, the token transaction. So the trading of the token for Bitcoin occurred on a blockchain, and the confirmation of that was done on a network where the majority of the nodes are in the US. And that was a factor in finding that it was okay to apply American securities laws to this ICO. That's a little surprising, a little depressing that that's the way the court was viewing it. Probably the plaintiffs argued for that, but it's a fundamental misunderstanding, in my view, of the way blockchain works, as opposed to a centralized exchange where you can say, here's the company, the exchange, where the transaction took place. We know where the transaction took place. The blockchain network, it was a Bitcoin transaction. The Bitcoin network is around the world. The transaction took place around the world at the exact same moment. So I don't know what the court's supposed to do with that, but that's not how the court analyzed it.
All right. We have another question. Is there any sort of general all-encompassing model that applies to all types of tokens for value? I think aside from the framework of thinking about sort of what are the property rights and the rights that the token gives you, probably not, right? In the same way as if sort of any kind of portfolio that you hold, you're going to value property differently, like real estate differently than you're going to value stocks. You really have to customize the valuation model to what exactly it is that the token gives you. As I talked about, and this is why I really like the commercial real estate example for securities tokens, even something as simple as, the details of ownership for partial ownership are really important. Do you have to contribute, a maintenance fee? Do you get income streams from renting out? These are all things that materially impact the value of this partial ownership share. So that's why we like to think about things in terms of sort of rights and go from there. but it's also one of the reasons why this field is so interesting. All right. So I think we're going to do we have one more?
I've got one more. So this is, have there been any disputes that involved an analysis of the nature of the crypto asset involved? So depending on what you mean there, the answer is either yes, there's at least a couple, or yes, there's a ton. If you mean it broadly in terms of analyzing whether a digital asset constitutes a security, there are many examples of that. But if you mean a deeper analysis into the nature of the digital asset, the cases really aren't getting that deep yet, which raises a point that I wanted to make earlier. I kind of skipped over it, which is if you're in litigation, crypto litigation, one of your big challenges will be convincing the court that your token, or the token that's involved, is different than all the other tokens that are out there. A lot of the decisions we see, and a lot of the scholarship we see outside of court, treat tokens the same. This is what Stephanie's been talking about the whole time. You've got to do some economic due diligence on what's going on with this token. They're all different. Courts are treating them all the same right now. Oh, this is a cryptocurrency case. I know what Bitcoin is. This must be basically Bitcoin, some new flavor of Bitcoin. That's the level of analysis we're seeing. The one example I'll give you of a court trying to determine the nature of a digital asset was an insurance case in Ohio State Court, where someone had some Bitcoin stolen and made a claim for stolen property to their homeowner's insurer. And there's a provision in there for a claim for money. And the whole dispute was, does this Bitcoin constitute money under the insurance policy? It was very interesting the way the court was analyzing the question. Ultimately, they ruled that it was money, and their ruling was based almost entirely on IRS guidance of how the IRS views Bitcoin. And it was a very interesting case discussing the nature of Bitcoin, this particular digital asset. But I think in the future we'll see some more cases get into the nitty-gritty as litigants figure out that it's important to distinguish their token from all the other tokens that are out there.
Okay, great. Thank you very much. So that is the end of our Q&A. Thank you, Daniel, very much for joining us and talking about some really interesting cases around tokens and crypto. So we will be sharing the recording and the slides after the conclusion of this. And if you have any questions or further follow-ups, please don't hesitate to reach out to us at Prysm Group. You can reach me at stephanie.hurder@prismgroup.io. Reach out to Daniel and his firm. And thanks very much for joining us, and hope to see you on the next webinar in the series. Have a good day, everyone.
Thanks.